152 now introduces certain acts which endanger sovereignty, unity and integrity of India. And I am fully conscious the observations of Honorable Supreme Court in the Kedarnath case and Red Water case. But how it is going to play out? How, Madam Chaya Sharma, I would like to have a comment. Police is going to exercise the discretion whether to raise a case on the BNS or under Makoka or UAPA, whose provisions have been directly incorporated without the protections available over there. So, with these comments, I would now like to invite Madam Bhati.
So may I intervene?
Yeah, please.
Audition.
Yeah.
Thank you so much for taking 20 minutes for giving such beautiful and excellent presentation, sir. And since the time is limited, and the panelists have agreed that they will be happy to interact and have an interaction with the probationers and the officers who are present. Ms. Bhati is also agreed, and Mr. Ghosh Kara, Ansari Sir, Chaya, so all are of the same view that they would like to have an interaction.
We just share our experiences and then open it for.
So let me set that I will. Yes, set the timelines. That's very important. So I would say, may I say with your permission? So I would suggest each panelist to give bullet points, okay? Because you're all, it's an educated, it's a very kind of a well-informed, intellectually stimulating audience, distinguished category. So give your bullet points in 3 to 4 minutes each, and then we take the questions and have an interaction. Is that fine? Are you okay, ma'am? Then rather going through the provisions of the Act, what do you want? Tell me. Are you okay? Lovely. Great. So, Ashwarya Bhati, Additional Solicitor General.
No, not really, sir, but thank you very much. So, yes, I just want to share some of my experiences, though I think it's still very new. It's just been a month that the provisions have been notified. By the time and I exclusively practice at the Supreme Court of India, so by the time the matters come up for the Supreme Court with these new laws, it will be a long time. But some experiences that I have dealt with, I just want to make those points. Ek sir mentioned, first thing he mentioned about overcrowding of jails. That was one experience that we had just last week. A bench headed by Honorable Justice Hemapuri asked Union of India that what is your stand on Section 479 of BNS? It's not BNS, but I'm still letting you know because there is a new provision added, proviso added in that which allows first-time offenders who are of a certain kind of offences which are punishable less than 7 years. It allows those first-time offenders to be given bail on 1/3 of completion of their sentence, whereas the previous provision was only for one half of the sentence. They asked the views of Union of India whether it will apply only to offences which are committed after 1st July or will it also apply to previous. We had a discussion amongst the officers, NHA officers, and we decided to give this because this is a procedural aspect of the law. Therefore, it should cover every under trial who has undergone 1/3 from 1st July onwards. So that interpretation court has accepted and court has made it part of their order. They have directed all under trial committees to look at all under trials who have completed 1/3 and fulfill those criteria, first time offender, etc. etc. One example I definitely want to also give you. One day, one late night brief came to me which had a High Court judgment running into 1200 pages. Late night files when the High Court judgment itself, which is the bare necessity that you have to read before you go stand before the court, if that itself runs into 1200 pages, then you know that you are in trouble. When we opened the files, we realized that this is the Mumbai blast case of 1992. Why was the Mumbai blast case still in Supreme Court of blasts that happened in 1992? This was apparently the second trial that had taken place for accused who were absconding in the first trial. And now the records were summoned back by the trial court for the third trial, which had to go underway for the accused that had been apprehended now. So the new laws actually does away with that kind of thing, allowing people in absentia to be investigated, to be tried. And since we have audience here, you are all from all the three limbs, I think that is the most significant aspect of law that you need to inculcate in your, so that, we don't have these multiple rounds going up and down through the appellate court. Nithari case also, recently I was dealing with this. This is also, one conviction has already taken place, but there were 18 cases for Nithari. So the rest of the cases will come one by one. Another interesting discussion, sir mentioned again about section 377 that has gone missing. Now section 377 was decriminalized by the Supreme Court only qua consensual sexual activity. So the aspect of non-consensual sodomy and bestiality, there can be no consent in bestiality. You are dealing with animals who don't have a voice. So those aspects are still missing, and High Court has already said, so I think that is one. And I was told by sir to red flag the aspects that are there in the law. We didn't want to, tell you about the laws. Another aspect that I am dealing with in the Supreme Court is there are TIL petitions where transgenders are asking for the same protection as available to women in the BNS. They are saying that provisions against them are not sufficient. The stand of the union in those petitions is that the 2019 Act, which protects and prevents all discrimination against transgenders, does prescribe for sufficient punishment, and it includes, the next voice is going to come about gender neutrality of all sexual offences. Those are journeys that nations will have to decide. I don't agree with sir that we need to make them gender neutral. We don't have enough perpetrators as women today, sir. Law cannot be made for exceptions. Law has to be made for the general masses. So when we have enough women in the workforce and enough women as perpetrators of crime, then we will make them gender neutral. That's my view on it. And one more thing that one more case that I'm dealing with is a challenge to the sentencing provision, where there is gang rape, etc. And there is a minimum punishment prescribed is for remainder of the life or death. So that takes away judicial discretion. That is also a challenge. It's still very much. Some red flags.
Thank you, ma'am, for really flagging some very important and critical issues with your insights as Additional Solicitor General. Now, may I move on to the permission of the Chair to Naveed Ahmed. I'm sure he's going to be sweet and short, as he's always says.
Thank you, Mr. Mayor. Thank you very much. Thank you for inviting me to this August gathering. I'll straight come to the point. What are the challenges in the implementation of BNS? The first thought that comes to my mind is the same as the challenges that were as part of the ITC. If 95% of the law remains the same, the challenges perhaps also remain the same in terms of substantive law. But in terms of the additions that have been made and the provisions that have been dropped, most of which have already been covered, community service for about 6 offences with no clarification as to what would amount to community service can have very absurd consequences. And we are talking of a place where we've had rape victims being asked to tie rakis to accused persons, to marry accused persons. And in such a situation, I think it's very important to have very clear guidelines as to what should community service be. And the second bit about who would enforce it. Is there a mechanism in place? Who will monitor whether community service is being performed or not? I think all of those concerns remain, and this is perhaps where a state-level intervention may be required through maybe rules and guidelines. But I think a very grey area, but it is almost going to be used. It's going to be used a lot because of the offence of theft being included in it, where petty theft, where the value of the goods stolen is less than 5,000 rupees. The other major concern, of course, is the offence of Terrorist Act, which is basically a replication of Section 15 to Section 22 of the UAPA. The concern here is that now you have a situation where a police officer is to take a decision whether the case would be filed under UAPA or under BNS. There may be some procedural differences. Sanction is required to be sought under UAPA, which may not be the case under BNS. So it's a situation where the facts of the case may be the same, the concerns of the state may be the same, the implications of the actions of the accused person may be the same, but we can have two divergent processes taking over. The third concern was perhaps on the organized crime front, subject to correction. I think we would now have a situation where all the state level laws have now been rendered repugnant because the union legislation has occupied field. And if the union legislation occupies field, even if it's after a state law has come into the picture, by the application of Article 254, all the state level laws on organized crime, to the extent of their overlap with the union law, which is BNS, will stand repugnant. Now they'll have to perhaps now go back to the president for a sanction. Now this is again a challenge for the states to look into whether they want a special law or not, because I think most of the provisions are have been included in the BNS. But even, I mean, all of the other provisions have also been discussed, including 377. One of the concerns that, the challenges that I think is very crucial is how do you translate the idea, the objective behind these new laws into action. The objective of the laws is decolonization, is creating a citizen-centric justice system, is prioritizing justice over punishment, and to create a modern system. Have there been enough changes to do this? I don't think so. I think there is a lot more to be done. And I think a lot of that would depend on all of you here, the implementing agencies, to translate the objectives of the law into action on the ground. So when I say that, what is decolonization? Unless our powers of arrest are exercised so cautiously, and 86 lakh people don't end up in police stations every year arrested preventively, there is very little in the way of decolonization. Unless we get it back to the table and discuss the 25 preventive detention laws that are already in place in the country, and lakhs of individuals arrested under them, preventively detained under them, there is very little that we are doing in the way of decolonization. The same is true for creating citizen-centric procedures and prioritizing justice over punishment. The prison system remains the same. It was a system conceptualized 150 years ago. It's a system that continues today. 3 years of punishment for the offense of cruelty, 3 years of punishment for the offense of not submitting information to a public servant. What is this 3 years supposed to do? In the same prison, this person subjected to the same prison discipline. How is this 3 years supposed to change it? And I think that is where citizen centricity, creating a modern system, creating a system that prioritizes justice comes into the picture. I think that's about it.
Sure. Thank you so much. Thank you so much, Ravi, Amit, Chief, for being so brief, and he really clearly, expressly, really flagged the challenges. And he's of the view these are the same as we had in the IPC. And he has listed some of them. I think they are very, very important for us to reflect and to act upon. With these words, with the permission of the chair, may I move to our legal, Senior Advocate Sanjay Ghosh. You have 5 minutes. Yes, sir. I'm saving time for discussion.
Hi, am I audible?
Yes.
Just before we came in, Maheshji said that this is a Sarkari function, just be a good boy. But Parashar sir has in his diplomatic way said what all we have to say. So I don't have to be a good boy with you guys anymore. As lawyers, whether legal or not, we only read a law if we are paid for it. And if it's required. So I was called for a function to talk about the this Evidence Act 2 weeks back. So then I came up with an article called All Ghodas Are Not Equal Before the Law. It's published in the Bar and the Bench. If you Google, you'll find it. So for today, my profit of this, though I don't get paid to come and talk to you here, is I have now written another article called Paramas, Palanquins, Cannons and Horses on the Road to Nyaya. How decolonize is the new penal law. This will come up in 1 or 2 days. You can Google and you can read that also. So coming to the point of decolonization. Now, for example, just to give you briefly, that has the decolonization been achieved? There is a section 76 of the Penal Code on general exception on being bound by law, and the illustration said a soldier fires on the mob by order of his superior officer in conformity with the commands of the law. A has committed no offense. Now, you would assume that Macaulay in 1857, 1860 can write it, but you have copied it verbatim in 2023 in section 14. Now, for example, sword, club, cannons, section 18, section 25. We are in the age of laser weapons and automatics, but you still continue cut and paste करके वही stick, club, cannons, etc. It gets even funnier. For example, 43 years after Macaulay wrote the penal code, for the first time you had an aeroplane journey. But when you make the new law in 23, you are still stuck with vessels, boat, chariot, palanquin, chariot in section 121, chariot and palanquin, bullock cart in section 303, horses in 315, and ships in 324, 330. So we have not even crossed palanquins and chariots. Now medical science has improved. Now no doctor does trepanation or cutting the stone. Cut for the stone is when you would open the body and take out the stones from the kidney, literally, physically. It would happen in 1860s. Trepanation was when you would make a hole in the skull and take out the matter from the skull. Now you have craniology, craniotomy. But we have done cut and paste, section 27, section 92, वो सब एक ही हमने रखा है. Including words like paramour, entreaties, entices, unloose, concert, all. But in law, language is very important. So that's why I'm not trying to nitpick. Please don't think I'm trying to nitpick. But language of the law is very important. Indigo plants. Who does indigo cultivation? Illustration in section 318 is still indigo. जो उन्होंने रखा था indigo उन्होंने रखा है. But जहाँ उनको illustration देना था, where they have to apply their mind in very critical sections like section 69. I was joking with Chayaji. I was saying that you are going to make us lawyers very rich. Section 69 is sexual intercourse by employing deceitful means, including promise of promotion. Now, if it is a non-consensual sex, it already comes within rape. Why do you have to have a separate section? Now, in that, they did not give any illustration to explain and to guide lawyers and police and judges, because उसमें तो अपना दिमाग लगाना होगा तो करा किया नहीं उन्होंने. Similarly, another one, section 152, the elephant in the room, endangering sovereignty, unity, integrity of India, including economic threat to unity of India. No illustration because added for the first time. So where they had to give illustrations to guide the judges, lawyers, no illustration. Where they had to change illustrations with time, it remains the same. So colonization, decolonization, I don't know. A lot of things have been said. I think Parashar sir has brilliantly summed up all those issues. So there's no point in me taking time and repeating what has to be done, what is left out. But I just want to flag something, and I think that is most important for all of you. In decolonization, what is the most important thing, and that's the elephant in the room, and that is that we are dealing with an act of 1861. Now, Ansari ji will say it's 1860. क्या बेवकूफ इसको पता भी नहीं 1861 बोल रहे हैं. I'm talking about not the penal code, sir and madam. I'm talking about the Indian Police Act. I'm talking about the Indian Administrative Systems, Indian Administrative Service Act. So what is the, after this code is coming into effect, you had that horrific rape in RG Court, right? So do mandatory sentences, do harsh sentences, give justice, deter crime. It's an issue, please think about it. After you had this, the Bhanasur, the Bharatiya Nagrik Suraksha, I call it the Bhanasur, Bharatiya Nagrik Suraksha Adhiniyam, which you post lunch they will talk about Bhanasur with you. After Bhanasur, there was a heartbreaking clip that we had day before yesterday from a police station in Madhya Pradesh, where this tribal old lady and her niece, her nephew, was beaten up in the police station. So the most important decolonization issue, sirs and madam, is you have to understand that the colonial system of treating the citizen as someone who is a subject has to change. That mentality has to change. And I dare say even for the judiciary, the citizen is the recipient of your service. The citizen is your boss. As an administrator, as a policeman, the citizen deserves your respect. You have to salute the citizen. So whether that decolonization happened or not, I don't know. I'm sorry I could not be a good boy, as Mahesh said. Thank you.
There's a clapping for you, why? Because you don't charge for coming here and speaking to us. But certainly we will we are giving you flowers and we'll give you memento as well after this is over. But I just want to flag one issue.
None of the speaker is taking the queries and the questions.
No, we will do that. Excuse me, we are saving time, we will have that. Please have patience. First, please listen to our panelists. They are very eminent people, and we had Dr. Ghosh's presentation. So, sir has really talked about the decolonization. Have we really decolonized or not? That's his point of view. But let me tell you one thing. It's not that we want to hear the Sarkari views. I'm sorry. If that was the case, I would have not invited Mr. Ghosh, Mr. Naveed. It's very important. I tell my probationers that you should always know the counterfactual. And the counterfactual is the criticisms. Whatever are the articles which criticize you, make them sit with you and talk to them. And be as critical as possible. Then we can come out and discover the truth. So, it's not that you want to listen to the Sarkari. I'm sorry. Prasad sir is there, I am here, Sarkari, madam is here, Naveed bhai. So please don't go with that view, by the way. With these words, may I move on to a very learned public prosecutor. He's very well known in the country, and I discovered him from one senior advocate. Thank you. And I am sure you will take 5 minutes. Yeah, because we have because people are impatient to ask. Yes, thank you.
An officer of the court with the most disliked person in the world. Never was a different counsel. When you are presiding officer, you are the victim. When you present our perspective and purely legal aspect of matter, we are bound to decide. We are the prosecutor, we are also supposed to know everything from the act to side. If any questions crop up, legal issues crop up, we are expected to answer to the learned presiding officer and to counter the learned responses. Give some ideas to what I know. And we are also expected to be very quick in our response, even without going through the file. So we are also expected to be very precise, to prove our case beyond our shadow of doubt, beyond iota of doubt. Suppose I am asked to prove that on 25th December 2020 it was raining. So what I am expected to do? I am expected to bring the God of rain to prove that fact. But the law permits me to prove the fact by way of its probability distance. This is why evidence has said when the fact is said to be true. But that aspect never be taken to court. We are always expected to each and every fact by direct evidence. If I prove that fact, that object particularly present by producing the weather report from the weather department, probably I am not considered to have proved that fact. So my strategy prosecutor is enormous. So what we say, what we think about these new laws from our perspective, we expect from these 3 criminal laws that our task will be made easier. While we are getting more clarity in the definition part, more clarity in the provision part, more clarity in the punishment aspect of matters. So keeping in all the aspects, we have to test this effectiveness of the criminal law on the touchstone of this definition part and everything. The rest of this is open and we will discuss this.
Thank you, Mr. Prasad. That's lovely. Thank you so much for giving another perspective as a public prosecutor. Now may I move on to our very respected